to the court how many of these you want to put in, or you intend to rely on. If you read CI 47 and CI 87, you intend to rely on. That's the expression. Now, you will recall that the first and second respondents complied, and the petitioner did not comply initially. And the petitioner then came for leave after we had filed our witness statements to file his witness statement. Be that as it may, the many attempts to put impediments in the way of the full trial gradually were removed by the court, and we got to the full trial. The petitioner initially called 2 witnesses who were expecting will come and make their case. And for all of those who have followed the trial so far, it begs the question, or it remains at large, whether or not the initial 2 witnesses were able to make the case for the petitioner. The petitioner then sought leave to bring in a 3rd witness, Ms. Rojo Metzelnunu, who then brought in a witness statement and then came to testify. And then at the end of Mr. Rojo Metzelnunu's testimony, without any compulsion from any quarters, the petitioner announced to the court that he had closed his case. He was done. He had finished making available to the court all the evidence necessary for the court to find in his favor. The first and second respondents, when given the opportunity, then announced that they were also closing their case. They did not think that the petitioner had raised any reasonable cause that required them to bring in witnesses to come and testify, despite the fact that they had initially suggested to the court that if it became necessary, these were the witnesses they intended to rely on. It is at this point that the petitioner has brought a new application to the court, after the court has made orders that we should file our written addresses, I think by Thursday, by Wednesday, towards final judgment. Now, the petitioner is asking the court to give it permission, because it's not a right, to give it permission to go back and reopen the case and adduce some new or some fresh evidence. It begins to beg the question, why would somebody who has told the court that I have closed my case, I've made my case, I've brought all the evidence and the witnesses that I believe can make my case, who earlier argued that this was an ironclad case, this was solid on all fronts, why is the petitioner now asking for permission to go and open the case to adduce new evidence? When you ask, the argument they make is that because the Electoral Commission, through its chair, advertised to them, indeed the word they used earlier today was promised, that you also get in the votes. Well, as has been explained by our counsel and indeed the bench through its previous rulings, the response to the court's order to file a witness statement and even the affidavit on interrogatories do not constitute a promise to get in the witness box. And in any case, if you have an opportunity to cross-examine, you cross-examine when somebody has led evidence in chief. So if the respondents have not gotten into the box to provide evidence in chief, what is this cross-examination going to be on? The court has already ruled that a party cannot be compelled to adduce evidence. Today, you have seen our colleagues come with an application asking for a subpoena. What's a subpoena? To compel the EC chair to get into the box. So the very thing the court said the last time we were here, they've come with an application with a different name or different instrument asking the court so to do. You also had learned counsel on the side of the first respondent and second respondent raise a number of reasons for which the position of the law does not support the argument that they are making. And I hope you took notice of the fact that for several minutes, the Venerable Kojo on his feet was citing various authorities in times past that do not allow the party, that is a petitioner, to do what he's seeking to do. I want to end by reiterating 2 of those authorities. One, Poku versus Poku, the former Chief Justice Georgina Wood. And I just read to you, an application to adduce fresh evidence. And why we are saying this is fresh evidence is because when you come and ask to reopen your case, why are you reopening your case? You want to reopen your case because there may have been something that was unavailable to you, which you are making now available to the court. And that is why we're asking the court to apply the rules of adducing fresh evidence in this instance. If not, then you are saying that you want to lead further evidence on something that you've had an opportunity and you've led evidence on already, and you are now probably thinking you didn't do good enough of a job, and that's why you want to reopen. But the learned Chief Justice, as she then was, said an application to adduce fresh evidence is clearly circumscribed and only operates within its statutory limits. The rule is therefore intended to assist an applicant who has made a genuine attempt to look for the evidence and has met with failure. Courts ought therefore to be adept at unmasking attempts by a dissatisfied party coming through the back door and under the cloak of having come by some new or fresh evidence, seeking to fill in the gaps or lapses in their case. For the rule is meant to aid the slothful. The rule is not meant, I beg your pardon, for the rule is not meant to aid the slothful or the indolent, the careless, the negligent, or the reckless litigant, whether acting pro se or through counsel. So whether it's Mr. Mahama or his lawyers who have been indolent or careless, negligent, reckless, the rule does not support them. The very final quotation that I want to reiterate, as articulated before the court by the Venerable Akutuampao, was in the case of Berima Jemfi and another versus Bedu. The Supreme Court, Koramsa Kodiado Olenu and Blay, Justice of the Supreme Court, speaking through Olenu, observed at page 597 that, and here's a quote, the plaintiff could not have called any of the other eyewitnesses because they were the very people against whom she was litigating her title. And please listen to this part. The Supreme Court says it will be nothing but madness for a party to a suit to rely on his opponent to prove his case. The Supreme Court of the Republic of Ghana says it will be nothing but madness for a party to a suit to rely on his opponent to prove his case. You heard counsel on our side lay all of these authorities before the Supreme Court, and we look forward to their ruling tomorrow. As whether or not you heard the compelling legal arguments with authorities backing it from the other side, I'm sure tomorrow when the justices came, they will tell us, or when the justices come tomorrow, they will tell us which of these arguments and which of these authorities have made their place. Those will be our comments. If there are questions, we're happy to take them now. Yes, sir.
The lead counsel for the petitioner asked for interrogatives. He argued in court today that your lead counsel argued then that you said that the petitioner will suffer no injury